if, for instance, if there are other sovereign guarantees that are given, they may themselves be actionable separately as well. So I think that is a basic question that I would perhaps ask Vikas if he is taking that extreme position. I don't know which position he chooses to take. There has been a lot of literature on the umbrella clauses. I mean, Pramod also pointed out before this meeting on James Crawford's lecture at Freshfields a couple of years ago. I found a couple of articles in the IBA journals by one Salatino, and there's been Anthony Sinclair taking on board the entire history of umbrella clauses. And I think all of this has focused quite closely on the language of the umbrella clauses. So going back to the initial simple umbrella clause that Anirudh had proposed, that, if I recollect correctly what he read out, I don't have it in front of me, we didn't share that. Firstly, I think it contained any obligation. Any obligation in my mind would include contractual and non-contractual. Perhaps he may have used the expression assumed or entered in, or obligations or commitments, it is assumed with regard to investments. Again, that assumption of the obligation may be by way of a contract, and merely because it is by way of a contract does not exclude the ambit of claims under the BIT. Emphasizing phrases such as shall observe and shall constantly guarantee, to my mind, are not essential aspects of such clauses. And finally, whether the investment is to be specified or to be left general, again, is, I think, a matter of negotiating power. So I want to quickly end by again emphasizing the points made in favor of recognizing the full power of an umbrella clause. I do not want to convey a sense of extremism by saying that every umbrella clause ought to be read as broadly as possible. That is not what I'm saying. I'm saying that there must be a full effect given to the words of the particular clause. And the more recent, some of the arbitral tribunal decisions, I think some of them have been mentioned, others that have not been mentioned, maybe Sempra Energy versus Argentina, on the violation of contractual commitments in relation to licenses. Eureka versus Poland has been mentioned, and I think LG versus Argentina has also been mentioned by me here so far. And I think all of this, I think, emphasizes the correctness of the SGS Philippines on the first issue of jurisdiction of the tribunal on considering contractual claims. And I think, in my view, SGS Philippines got that right vis-a-vis SGS Pakistan. And I think it's a matter of specificity as to whether a particular claim falls within a clause or not. Thank you.
I'll probably take the question Shreyas put to me directly to start off this entire discussion as to whether by not allowing contractual claims, umbrella clause is rendered redundant, as in there's nothing that is left within its ambit. On that point, I'd like to say a BIT is not exclusively an instrument which creates obligations. A lot of times, a BIT recognizes obligations that already exist in customary international law, be it the most favored nation, be it fair and equitable treatment. The very fact that a BIT mentions fair and equitable treatment does not mean that the remedy would have been otherwise unavailable had the BIT not been in place. And similarly, and quite a few commentators have taken this line where they say the umbrella clause merely recognizes and clarifies that an investor is given a right to go and challenge state actions which would otherwise have been subject to challenge under customary international law. But by specifically recognizing it, it just makes things quite clear. So it is not completely defunct, the umbrella clause, even if it is interpreted narrowly. And on that background, what I'll try to do is, I'll try and develop some policy rationales for why an umbrella clause needs to be interpreted narrowly. and then go on and see if the language of an umbrella clause permits such narrow interpretation, or the wording of the umbrella clause which we are using as reference here. At the very outset, there is a contract that has been entered into between a contracting party, that is a state, and an individual investor. That contract is subject of some detailed negotiation. And as is in the case of SGS versus Pakistan, the dispute resolution clause in that case was hotly contested. The Swiss government, the investor from Switzerland, wanted the UNCITRAL model arbitration in place. Pakistan government wanted a domestic arbitration. And this issue was considered a deal breaker. And it is in that context that the parties agreed to domestic arbitration in Pakistan in that particular contract. Now, if you think of this entire debate in just this one context, is the entire negotiation that Pakistan undertook to ensure that domestic arbitration is what is in place. And it may have conceded a few other things. You'll have to realize that when a government negotiates something, it has to give up something else. So is this balance that the parties have arrived at in the contract? And remember, at that time there wasn't jurisprudence and umbrella clauses, so it wasn't clear whether there is an alternative avenue available. And even to this day, given the divergence of arbitral opinion, it's not clear if an investor has an alternative forum. So the specific agreement of the parties in the contract has some value, and that value needs to be maintained. That is, like, at the overarching level, one policy strand that we can take. The second one is whether the exclusion that SGS versus Philippines recognized, which is if there is an exclusive jurisdiction clause in the contract, that will mean that the ICSID tribunal will pay deference to the contractual dispute resolution mechanism. Is that grounded in the language of the treaty? If you want to interpret a treaty with its literal meaning, you will have to go the full extent and say, this is an obligation you have undertaken, and the interpretation of the treaty cannot depend on an interpretation of a contract which has been entered into subsequently. So you cannot confine the ambit of what the umbrella clause means by whether the parties ultimately choose exclusive jurisdiction. And therefore, at a conceptual level, there is some difficulty in trying to confine the interpretation of an umbrella clause by subsequent developments. I'll give you a few other examples to highlight why even at a feel level, and I think perception of the effect of a clause is very important to how the arbitrators interpret it. I'll give you two examples. Take a construction contract in which there's a contract to build an extremely technical nuclear facility. The contract provides, even if not at an exclusive jurisdiction level, for the dispute to be determined by an expert in the field. The parties here know that it's a complicated contract, know that the consequences can be so severe that if a person who doesn't know the area adjudicates on it, they might not get a fair settlement. Would in such a case, going off to an ICSID tribunal with generalists in the panel suit the purpose? Would it be something the parties intended? Would it be equitable? Would it be fair? Second case, take a construction contract again. Say you're talking about adjudication, which is basically a shorthand form of a dispute resolution mechanism, where the parties have specifically consented to have a speedy resolution of their disputes. If the parties have so consented, do you then want to drag them to ICSID arbitration, which I know White Industries is an exception where 2 months were taken to give an award, but more generally, ICSID awards can take quite a long time. In bilateral investment treaty arbitrations, more generally, India is not part. So, if you take them to investment treaty arbitration, and there you get drawn on for 3 or 4 years when the parties specifically in their dispute resolution mechanism wanted a speedy resolution of disputes, that again takes away from the intent of the parties as they're negotiated. And that might be another policy consideration for us to rethink whether at the outset you want to take contractual claims and adjudicate them in a treaty breach. Another policy-based argument. By its very definition, an umbrella clause is an asymmetric clause, i.e., the state is the only party on whom the obligation is imposed and not the investor. So if in a contractual claim that comes about, a state may have a legitimate set-off claim or a legitimate counterclaim to the contractual dispute. The state will not be permitted to raise that in the ICSID arbitration, simply because the umbrella clause does not permit it. The umbrella clause only says that the state undertakes an obligation, and that is the sole basis on which the arbitrator has jurisdiction. The arbitrator in particular does not have jurisdiction to consider a breach by an investor of a contract. In that case, would not the contractually chosen dispute resolution mechanism be the most appropriate to fully consider the entire issue and all claims of set-off and counterclaim and come to an ultimate conclusion? Another thing, as to the existence of a pending dispute, and it was sometimes suggested by, I think, Anirudh, that a proceeding which is belated, i.e., if an investment arbitration starts first and a domestic arbitration second, the domestic arbitration should be stayed in favor of an investment arbitration. I don't think that has a conceptual basis either. As the speakers before me rightly pointed out, the effect of an umbrella clause is not to divest a contractual dispute resolution mechanism. The contractual dispute resolution mechanism survives even if there is an umbrella clause. So you cannot ask the arbitrator as a matter of right to stay. You will inevitably, the arbitrator will have jurisdiction to continue parallelly if required. In such a case, would a contractually chosen dispute resolution mechanism be better, or would a more general remedy under an investment treaty be more appropriate? And that actually makes things more complicated when, if an investor goes to investment arbitration, start proceedings, the only thing that the state needs to do is to start off a domestic proceedings. Then you can always go back to the investment arbitration and say, I can't be prevented from pursuing arbitration or litigation in courts because my contract permits me. You are considering exactly the same issues. Do you want to risk a duplication of proceedings, a conflicting award, or do you just want to stay proceedings pending domestic court's determination, as happened in SGS versus Philippines? So here, even if on an interpretative level, you come up with a solution of saying all contractual claims can be addressed in an investment arbitration, you have the problem where a unilateral act of a state can make the whole arbitration with the investment treaty completely pointless. They might stay the proceedings and ultimately look into whether that domestic court proceedings were fair and equitable, or whether the contractual determination was correct. But you are effectively allowing one party to decide how long the arbitration takes, how issues are determined, and so on and so forth. Given all these problems, I mean, I could probably identify a few more, but I think I've sufficiently demonstrated that there is a problem at a conceptual level and a practical level of allowing investment treaty arbitration in regard to contractual claims. The question is whether such a policy consideration sits well with the clause itself. Now, if you look at a clause which Anirudh is proposing, I think that is a useful formulation for our purposes. It says, each party shall observe any obligation with respect to investments. Now, the term any obligation can be given effect to with the aims and purposes of a treaty. You can talk about it being an investment treaty between two sovereigns, the contracting party being a state mechanism, being a state entering into the contract. So is it possible that we say that the state was wearing the hat of a sovereign when it entered into the BIT, and therefore when it undertook any obligations under an umbrella clause, it was while wearing its hat as a sovereign, and therefore it should not affect activities that it takes as a merchant? Possibly, not entirely sure, because it is not the most obvious interpretation of the clause. It's something that will have a little bit of a logical stretch. There are other proposals that are made. something that Mihir has written about also, about saying whether a investment treaty arbitration can only be permitted in relation to an investment. That is, only when a matter is so vital to the investment that if the contractual breach affect the whole investment and the entire investment is rendered redundant, that is the only case that an investment treaty arbitration can be brought. Even that argument doesn't sit well with arbitral jurisprudence, because most contracts have wordings like in relation to investment, and in arbitral jurisprudence, in relation to is considered a sufficiently wide term to have greater ambit of disputes within its realm than just the most vital or the most fatal of breaches by the state. So on a pure interpretation of the contract, it doesn't seem to fit well. Given all of these problems, the clause itself, unless the clause is being amended like Shreyas pointed out in the India BITs that he read out, does not seem to admit of an interpretation which can narrow it down strictly. So it has to be an arbitrator dealing with the issue to take a stance on it, and that I think is a rather unfortunate conclusion for me to reach, having given you as many policy implications, because the minute the arbitrator has to decide, there is the element of uncertainty. But in the limited context to which I could think about this issue, I couldn't find a way to confine it than to give the discretion with the arbitrator. With that, I conclude what thoughts I have.
Or apart, which one of you would like to go first? I mean, based on what you, either engage with what has been said previously, or you could perhaps think about adding to the debate. Yeah. Okay.
Thanks. Arbitrability and possibly arbitrability, and to that extent, I must say that the views that I express here are mine and not of the institution that I represent. Being as it is that issues of that nature will normally be dealt with by a tribunal and not an institution that is dealing with a case of that nature. I just want to set out the context in which this entire question of umbrella clauses comes up. Is that there is normally a bilateral investment treaty between two states. There is normally a portion of that bilateral investment treaty that deals with investments, and there are possibilities that there are claims under that chapter dealing with investments which provide for obligations on the states in respect to investments that are made in that particular state by investors coming from the other contracting state. There are three situations in which a simple contract claim can by itself be a claim under the substantive obligations under a bilateral investment treaty. The first of which is a situation where the contract claim itself may violate a substantive obligation under the BIT. I think an example of that is a case in Mexico, where there was a contracting party that was given licenses to carry out landfilling or construction activities. There was also a clause in the contract which provided for a renewal of the license upon expiry. The government didn't do that. What the contracting party then did was to bring a BIT claim on the basis of the argument that the non-renewal of the licenses itself amounted to an indirect expropriation and was a violation of the substantive obligations under the BIT. What it could have done was to bring a separate contract claim, but it didn't do that. What it could have done is to bring a claim under the umbrella clause, but it didn't do that. So therefore, that is a situation where a simple contract claim by itself can be a violation of the BIT claim. So that's one instance where you could have a situation like that. The second situation is where the clause that relates to dispute resolution in relation to investments is so widely worded that it also covers contractual claims. So you could have a clause that simply says all disputes relating to investment will be referred to a tribunal, either an exit tribunal or non-exit tribunal, as the case may be in that particular clause. And then that clause could potentially cover contractual claims also. The third situation is what we're really grappling with in terms of what are known as umbrella clauses, where the purpose appears to be is to effectively deem a contractual claim as being a claim under the BIT. And in my view, that's all it really does, is that it's a deeming clause by virtue of which a contractual claim then becomes a treaty claim. I think it's perhaps incorrect to refer to it as a clause that elevates a contractual claim to that of a treaty claim. and I think Vikas has alluded to that already, to say that the contractual claim is independent of the treaty claim, even if the treaty claim is ultimately based on the contractual claim by virtue of the umbrella clause. So all that it does in that sense is to bring any contractual claim or a dispute within the ambit of the BIT, because the clause provides for parties to keep all their obligations and to observe all their obligations. And which is why it is called the Pax and Servanda clause, as to the undertakings clause or the keeping of obligations clause. So broadly speaking, the clause is meant purely for contracting states to maintain or adhere to their obligations under the BIT, and that's the purpose of the clause. So the question really is whether a clause of that nature is to be given full effect to, or is to be given minimal effect to. And I think that's what translates into whether it has to be given a broad interpretation or a narrow interpretation. And that really depends on the wording. I'll come to that in a moment. There are a couple of arguments against the broad reading of umbrella clauses, which I just want to deal with briefly. One of which is that reading an umbrella clause broadly will render the other clauses of the BIT superfluous. I think we've already heard a bit about that, but I just want to give you an example of a situation where that may not really be the case. You could have a state, you could have an investor who set up a factory in a state. Let's say the state conducts a fighter jet test. The fighter jet crashes into the factory and it's completely destroyed, and they want to claim compensation. Now, there is an umbrella clause in the BIT, and if you were to give full effect to the umbrella clause, it would mean that any violation of municipal law would also be then a breach of the umbrella clause. Normally under municipal law, there would be an obligation for a state to pay compensation for damage caused. Let's assume this particular state does not have such a municipal law, but the BIT provides for full protection and security. So even if you give full meaning and full import to the umbrella clause in that particular situation, you would not be able to claim the compensation that you require, but you would still have to resort to the full protection and security clause under the BIT to be able to get the same kind of relief. So that's just an example of how giving an umbrella clause the broadest interpretation may not necessarily render other terms of the BIT superfluous. The other argument that is often canvassed against reading it broadly is that it renders the dispute resolution mechanism in a private contract superfluous. I think to that extent it's very important to remember that an umbrella clause doesn't take away the contractual claim. The contractual claim continues to survive and can be pursued independently. It's of course perhaps not the most desirable of situations to have parallel claims in any kind of situation. I think we've all seen that in practice, that you want to avoid parallel proceedings. But in this situation, that's something that has not been tested, and tribunals have not really been faced with a situation where there's a private contractual claim proceeding at the same time as a claim under the BIT. But legally speaking, at least, that would be the correct reading of an umbrella clause to say that the contractual dispute resolution mechanism continues to survive. Another important factor, I think, when we're looking at umbrella clauses is the context that we find ourselves in, particularly where we're sitting in India. The economic context in which you look at a BIT, I think, is very, very important. The purpose of an umbrella clause at the end of the day is also to promote investor confidence, and particularly in a jurisdiction of this nature, I think it's crucial to be able to support and promote investor confidence, to be able to have clauses of this nature in the BITs. We've heard a lot in the recent past about the kind of claims that have been brought against India under several BITs. We've also heard about how the government has reacted to say they want to exclude arbitration clauses from their contracts in the future. I have my own doubts about how prudent a measure that is in terms of encouraging economic activity and investment into the country. So that's something that I think we can ponder over. I also want to touch upon a couple of aspects of the umbrella clauses itself. Firstly, I think Vikas has already spoken about it briefly, but I'll just put that in context. So say, one of the issues that often arises in umbrella clauses is the scope of the obligation that the state undertakes under the umbrella clause. And that is something that depends entirely on the wording. We've seen a few examples that Shreyas has given us. And an example of a particular undertaking that a state may take is that it will adhere to particular commitments that it undertakes in regard to investments. Or it can say it will observe all obligations that it has entered into in relation to investments. A clause like that could perhaps be read to mean only contracts are to be adhered to, nothing else. It can say any obligation, that is perhaps the broadest clause that you possibly find. So you could have clauses that say obligations in relation to specific investments or particular investments. So that means that there's no general obligation, but it's only in relation to particular contracts that are entered into with investors. Another example of a very broad interpretation of an umbrella clause in the context of the scope of obligations is the question about whether this obligation extends to municipal law and whether a change in municipal law can also be an obligation that a state is adhered to, in the sense that I will not change my municipal law in a manner that will affect you. And a case that dealt with that question was LG&E versus Argentina, where there was a municipal gas law which was changed by the government, which directly affected the investment made by the company in that sector. And the tribunal in that case actually took the view that the umbrella clause must be given its broadest interpretation to say that changes in municipal law which have the effect of affecting the investment would also fall within the scope of obligations under the umbrella clause. So, but that's an exceptional case in that sense, and I don't think tribunals possibly go that far. But that's something to be seen and something to be pondered over. Another question that arises, of course, is the scope of the violations of the umbrella clause that one has to deal with. So, on one hand is the scope of obligation that is prescribed, and what kind of violations would then constitute a violation of an umbrella clause. So, therefore, there are questions about whether a mere breach of contract is sufficient for the umbrella clause to be violated, or whether maybe a legislative or an administrative act of the government or the state can violate the umbrella clause. And added to that is then the question of whether acts of instrumentalities of state, which Anirudh was talking about, can also be deemed to fall under the umbrella clause. And those questions are possibly will arise a lot in the Indian context, given the number of contracts that Indian state undertakings and the PSUs enter into. Question is whether contracts of that nature can then be elevated to a PIT claim to say a state undertaking has really breached the contract and therefore the state is now liable under the umbrella clause. So those are questions that we can look at. I think that's broadly what I have.